Hello and welcome UPSC aspirants to this explainer. I am joined by Sir today, and look, we are jumping right into a really high-yield topic for your General Studies Paper 2. We're talking polity, we're talking social justice. Specifically, we'll be tracing the entire evolution of labor rights in India, taking you all the way from the colonial mill workers right up to today's modern gig economy.
Now, to kick things off, I want to pose a question to really activate that critical thinking for your mates. How on earth does a 1918 colonial conspiracy case actually shape the legal realities of the platform worker who's, delivering your dinner tonight? It's all connected, guys, and understanding this exact thread is absolutely crucial for your exams.
Thanks, ma'am. Let's aggressively fast-track the historical context here. Picture this. 1918, Bahman Pestanji Wadia founds the Madras Labor Union to fight worker maltreatment. But here's the catch. Under British common law back then, forming a union was literally treated as a criminal conspiracy to restrain trade. No way around it. By 1921, during the Buckingham and Carnatic Mills case, leaders were slapped with massive penalties just for organizing a strike. So it took 5 relentless years of pressure before the Trade Union Act of 1926 was finally passed. That act was a total game changer, finally letting Indian workers organize without facing those civil or criminal conspiracy charges.
And sir, the sacrifice behind getting that 1926 Act passed was just immense. When faced with those steep financial penalties in 1921, union leader Vingal Chukarai Chettiar stood up in open court and defiantly told the judge that even if his clothes were removed to pay the fines, he'd continue to work for the trade union wearing only his loincloth. That right there shows the sheer grit of the early labor movement.
Absolutely, ma'am. And you see, this movement quickly fused with our broader freedom struggle. The protections from that 1926 Act really emboldened unions, like the Girni Kamgar in Bombay. They organized massive strikes after the imprisonment of Lokmanya Tilak. Naturally, the colonial state completely panicked. Since they couldn't just use conspiracy charges against unionists anymore, they pivoted. They cracked down using sedition laws in the famous Meerut conspiracy case and pushed draconian bills just to ban sympathetic strikes altogether.
Right. So let's shift our timeline to post-independence. That intense early ideological fire kind of cooled down into more structured wage bargaining. But here's the key takeaway for your polity prep. The core victory of that 1926 Act, it got absorbed directly into our constitutional framework. Under Article 1911C, the fundamental right of all Indian citizens to form associations or unions was firmly guaranteed.
But here is where we really need to put on our GS2 analytical hats, man. Let's contrast that historic 1926 Act with the recent Industrial Relations Code of 2020. On paper, the letter of the law looks identical. The new code actually retains the exact immunity provisions of the old Act. But the spirit? Well, it's severely restricted by crippling procedural roadblocks. Think about this. To even be recognized now, a union needs 51% support on the muster roll. In sectors with high casual labor, that's nearly impossible. Plus, a 60-day notice is now required before a strike, effectively putting workers in a state of endless procedural suspension.
And that brings us, sir, to the most glaring silence of all. 7.7 million. That is Niti Aayog's estimate for the number of platform and gig workers in India back in 2020. Yet the Industrial Relations Code of 2020, which was specifically designed to consolidate our labor laws, doesn't contain a single word about them. They are legally classified merely as independent contractors, leaving them completely outside this protective net.
Exactly. This creates a massive contemporary statutory vacuum. Look at the Fair Work India Report 2024. It found that not a single major platform recognizes a collective body of workers. But, history repeats itself. Just as those colonial workers defied the odds, today's gig workers are adapting. They're organizing via WhatsApp groups, like the Telangana Gig Workers Union, and they are fighting back. Recently, actual union pressure forced Zomato to reverse a policy segregating delivery fleets, a policy that workers felt endangered minority and lower caste riders. And meanwhile, since there are no central protections, 4 individual states have had to step in and pass their own independent social security laws for platform workers.
So aspirants, please note down these key takeaways. This right here distills our whole analysis into highly actionable points for a potential 15-marker GS2 question. You absolutely must be able to trace the evolution of Article 19(1)(c. You need to critically analyze that procedural suspension of rights in the 2020 codes, and of course, clearly articulate this current statutory vacuum surrounding Social Security for gig workers.
We will conclude today's explainer with a somewhat provocative, interview-style thought.
Bhagat Singh once famously said, "It takes a loud voice to make the deaf hear." Well, looking at the procedural hurdles and the complete exclusion of millions of gig workers today, we really have to ask, have the deaf truly learned to hear? Or is this century-old struggle for collective bargaining simply wearing a new digital uniform? Ponder over that as you prepare. Thank you for joining us today, and keep studying hard.